As a first point, mediation in Florida family cases is almost always, not in every case, but almost always required of the litigants. Mediation is a wonderful opportunity to resolve all of your issues. If you cannot resolve your entire case at one mediation, perhaps you can schedule a second continued mediation, or there's always an opportunity to resolve part of your case. That would be called a partial settlement agreement, whether in a paternity or a dissolution of marriage case. The partial agreement can involve issues such as timesharing with your kids. It can involve child support, temporarily or permanently. It can involve alimony on a temporary basis or as part of a final agreement. Whatever the case may be, you want to be sure to understand what mediation is and what mediation is not. Mediation occurs before a neutral mediator, qualified and approved by the Florida Supreme Court. That neutral mediator is not there to take sides. He or she is not there to provide you with a win in your case. The goal of a mediator is to find out if both sides can reach an agreement on some of your issues or an agreement on all of your issues. Keep in mind that litigating your case at mediation may not be your best approach. Perhaps the better approach, and the one that we generally recommend for our clients, is that you focus on building a bridge to the future. If your case involves timesharing, how will you and your co-parents divide time with your kids? Who will accept responsibility for healthcare decisions, for educational enrollment, for things of that nature, emergency decisions? Who is going to go on vacations, where, when, why, and how? These things are important. The mediator will help you come to an agreement by moving from side to side, presenting your offers if you're in separate rooms, or if you're together, may interject to make suggestions. Perhaps the mediator knows the school calendar in your district better than the litigants or the attorneys involved. A mediator is a great resource and can be extraordinarily helpful to trying to resolve all issues in your case. But again, a mediator is neutral. Convincing them of the worthiness of your case is not necessarily your primary goal. Your goal is to find out if you can reach an agreement, end your case at that point in time amicably, or as amicably as the circumstances will allow, keeping in mind your finances, your children's best interests, and your best interests all in one.